Thank you. You may be seated. Mr. Stephen Saladay is here this morning. He is the agent from the Department of Corrections who prepared today's pre-sentence investigation report. We are here today for sentencing on two cases. One is carrying a concealed weapon, which is a felony, and the other is brandishing a firearm in public. I have received the pre-sentence investigation report. I have gone over it. The defendant has a just to make certain.
No, Your Honor.
Mr. Harrison, same question.
Same answer, not for me either.
Allocution, Mr. Harrison.
This is perhaps the rarest of occasions, Your Honor, in which I'm not going to say much.
Oh, thank you. I'm
Because
sorry.
I have read the report, Mr. Saladay's assessment of the situation. I thought it accurately portrayed what occurred. I thought the tone was appropriate with regard to the fact that he doesn't apparently believe that Mr. Childers is a menace to society, and neither do I. In fact, I hesitated when he first walked up to the table because I've been calling him Z Chill informally because he's an exceptionally laid back, thoughtful, dare I say, mature young man who was merely reacting in a panic type situation and did something stupid. I think the recommendation is spot on as well, so I will retire my remarks at that juncture.
Mr. Harrison. I'm sorry, Mr. Carnes.
Thank you, Your Honor. Chill, thoughtful, and mature do not at all describe the behavior contained in this incident. I don't know the defendant, so I'm not arguing with Mr. Harrison that might be his normal demeanor. But I do know this incident, and it is frightening despite the offer, which I think is a fair resolution of the case. But this involves some very bad decision making. Someone could have easily gotten hurt or killed. And it was bad decisions all around. Anyone could have de-escalated the situation. Instead, everyone seemed to have escalated it.
This is where the case gets much more serious. The defense may see this as a young person making a terrible mistake, but the prosecution is looking at the potential consequences. Someone could have been seriously injured or even killed. In court, intent matters, but so do the risks created by the defendant's actions. Do you think being young with no major criminal history should carry significant weight here?
But the defendant has no criminal history. He's young, his brain is not fully formed. That's something Haida will recognize. He's close.
He's 25.
Yep.
Right, he does smoke weed, but anyway.
That will delay.
That'll impact it a little bit, but that's okay.
And
That's
you
law.
can't use marijuana and own a gun, which I don't have a way of enforcing that. It's a federal law, but it is a law. Anyway, there's a lot the defendant could learn from. I think the recommendation is appropriate. I'd ask the court to follow.
All right, Mr. Childers, you have the right to make a statement. Anything you wish to say?
No, sir.
All right. Well, I'll tell you, you probably got lucky. I know you might say, well, Judge, I'm not getting all that lucky because I've got a 5-year felony here. Sure, because you shouldn't have had a weapon. You don't have a lawful right to carry a concealed weapon. This was an incident that you did try to kind of do the right thing in a way. Granted, it was at a marijuana dispensary. You're lucky an officer did not. Well, I'll tell you what, they're really hard for officers to justify taking somebody into custody to do a blood draw. Should have probably done field sobriety testing. Had you had any marijuana in your system, it'd be a drinking and driving. So you can't have it in your system. You're going to the marijuana dispensary, and then there's some kind of scuffle, and you decided to go Dirty Harry. It's an old reference. You can talk to your family about it. Go Dirty Harry on these people. Well, no. So what do we do here? Well, if I put you on Holmes Youthful Training Act status, my concern here is that no, let me think out loud. Let me think to myself. It's silent. going to go partially along with the pretrial agreement. And count one, the court places the defendant on a period of probation consistent with the recommendation in the report for 1 year that is pursuant to the Holmes Youthful Training Act. The court adopts the terms or conditions that are listed underneath CFJ 145, pages 2 and 3. I find that they are well suited for rehabilitative purposes. Based upon the defendant's issues here and the facts of the case. If the defendant is successful with the completion of his HYTA, then he'll have the right to have that charge dismissed. The court concludes that the defendant, or highlights the defendant is not able to use or possess beverages or other intoxicants, which includes recreational marijuana. And the court sentences the defendant for that count 2.
Here's the major break for the defendant. The court is using HYTA, which is designed to give eligible young defendants an opportunity for rehabilitation. If the required conditions are successfully completed, the felony can potentially be dismissed. But this is definitely not a free pass. Probation, financial obligations, restrictions, and compliance all come with it. One mistake during this period could change the entire outcome.
2 days with 2 days of credit. The court assesses a $68 state minimum for that offense, a $50 state minimum for the second offense, $130 crime victims' right fund fee, a $300 court cost, a $500 fine. Hold on. I'm gonna make it a $200 fine, a $300 attorney fee, supervision fees of $30 a month or $60 a month if there's any electronic monitoring. Because the felony conviction is underneath HYTA status, we do not need to assess a DNA fee. Now, as to count 2, the court does not place the defendant on a period of probation. However, that means he's not underneath HYTA. So the only difference is I'm not doing HYTA on that offense. Why? Given him just 2 days of jail with the 2 days of credit, and by law, he must forfeit the weapon. That's why.
I think that's already been accomplished, Your Honor.
I'm just, right. So anyways, that's all. Have I missed anything, Mr. Salomon?
No, Your Honor.
Mr. Carr?
No, Your Honor.
Mr. Harrison?
Nothing, Your Honor.
Thank you. Now, nothing my comment about marijuana applies to or can be applied by law to medicinal. It seems a bit silly of a difference, but there's a difference. So, there you go. I don't think I have any point. Anything else? Okay, there we go. That's it. All right. So, because there's no, I don't need to advise the rights of appeal on the misdemeanor, because the felony conviction doesn't take effect until after the HYTA program. Therefore, I don't need to go over your appellate rights because that sentence is not yet final. We'll see you back within the next year. Thank you very much. We are adjourned. Potter just left. Maybe he'll come back. But this is a pretty simple file. Ms. McDade is here at Defense Counsel. We're here today for sentencing on a case involving a conviction for an attempted possession of a taser, and she scores a horrendously high 0 to 1 month guideline. Hell, I don't know if I've ever seen 0 to 1.
I thought that was the first in my career.
I think so. All right, thank you very much. Mr. Carnes, any amendments, corrections, or objections to make?
Just a small typo on CFJ 284, page 4, under marriage narrative, at the very bottom of that page, it says the defendant has never been married twice, with both ending in divorce. So,
Yeah, I don't understand that one.
I think if we remove the word never, it makes
With
sense.
her mind, she's never.
Yeah. Well, maybe she's never been married to the right person twice.
Yeah.
All right, thanks. I hope that's not one of them. They don't let them back. All right, thank you very much. We'll make that correction. Let's see if we can do something, Mr. Harrison, and keep it short.
I don't know that I have anything to add, Your Honor. I don't know that I have anything to add. I think it's an appropriate resolution. I had a discussion with Mr. Potter earlier today and told me the same thing.
All right, thank you very much. Carnes,
Your Honor, I also would just ask you to follow the recommendation. Thank you.
Ms. McDade, anything you wish to say?
No, Your Honor.
Sometimes it's good when people understand when they shouldn't say much. I never seem to find that, though. I talk way too much. So, this court finds that following sentences are reasonably proportionate. The court assesses a $68 state minimum fee, $130 crime victim break fund fee, a $300 court cost fee, and a $500 fine, a $300 attorney fee. Was there had to be a DNA fee of $60 payable to whom?
Wexford County Sheriff's Office, Your Honor.
Okay. 2 days of jail with 2 days of credit. Everybody notices what I did not say. I did not say any probation. So therefore, there's no supervision cost. What do you think there, Mr.? Well, you got a look on your face like you're shocked. What you got?
No probation.
Yes.
It was a 6-month delay, so it could be.
Oh, it's a delay. I'm sorry, maybe I didn't see that with my glasses on.
I'm sorry.
All right. No. Hey, thank you. I did not see that. We'll put a 6-month delay, 771.1.
Thank you.
You know what? Make it a 3-month delay.
Okay.
Just pay your fines and costs and I'll sign everything and get it done. DNA fee is waived. I'll take that off because it's underneath a deferral sentence.
Thank you.
Thank you, Mr. Potter. All right. Hopefully you don't object, and I don't need to go over your appellate rights since your sentence is not yet final. Pay your fines and costs, and you'll be good. If you don't pay your fines and, well, hold on. Gosh darn it, Miss Madam Clerk. What's the total amount? Do you think you can pay that amount off? It's a little over $1,000.
1,298.
I could extend your period for 6 months to give you more time to pay. Would you like that? Or would,
Your Honor.
let's go ahead and go to 6 months. Jeez. Here and I thought I was doing something good, but now I need to do it this way.
I appreciate the settlement.
Well, all right. You get it paid, we'll get it done. Thank you. You're adjourned.
Thank you, Your Honor.
Number one thing there is don't get caught doing anything illegal, like drugs. All right, our next file, people of the state of, oh wait, no. Sorry, this is a license restoration hearing. Michael Paul Schwab versus Secretary of State appeal to an administrative hearing conducted by the Secretary of State. One moment. See that a transcript has been filed. All right, Mr. Schwab, help catch me up here. You lost your license due to a couple drinking and driving?
Yep.
And how long ago was your last one?
11 or 12 years now.
Okay. And you are appealing the decision to reinstate full license, or did they deny you even a
Restricted.
restricted? They
Yeah.
denied you a restricted as well?
Yep.
All right, thank you. All right, Mr. Carnes, I have here the transcript. I do recall taking a look at that last week. A quick look here. What you got there, Mr. Carnes?
Your Honor, I focus primarily on the order
Yep, and that's what I'm looking for.
and primarily on page 3 of that order.
Yep.
I noticed that the hearing officer talked about prescribed substances a great deal, which is not part of the abstinence analysis. So I don't think that's appropriate. And then really, they focus on that the hearing officer may require proof that the petitioner present evidence from not less than 3 independent sources. And I understand he was not able to find people who could talk about his drinking. It sounds like because his drinking happened so long ago. So I don't think that the hearing officer made the right decision here. I do think a restricted license would be appropriate.
For these, on page 2 of 7 of the order, they talked about prescription medication. We had some in 2022, Oxycontin, what was?
Clear cell carcinoma, I have renal cancer.
Okay. All right. And are you still using substances like that?
I take my epilepsy medication. I can't take Tylenol now.
Okay. All right.
Very limited.
Let me continue to read through here one moment. Do you work right now?
I work part-time, but I'm retired. And I'm on the board of reviewing my township.
All right, thank you. What township are you on?
Springfield.
Okay, seems like I've seen you there. How long you been on?
I've only lived there for about a year, but Tim's a really good friend of mine, so as soon as he had the opening, yes, but I think it's because I'm a licensed realtor.
No problem. All right, no problem. All right, I thought you looked familiar, but I may be wrong. All right, hold on. There's a statement here I liked at the bottom. I say that like with a slight degree of facetiousness. General statements indicated that someone is sober does not provide clear and convincing evidence. Yet you're only required to provide statements. But I understand having represented people in these requests.
This second case shows a completely different side of the courtroom. Here, the judge is reviewing a license restoration decision and questioning whether the administrative ruling was reasonable. The key issue is whether the evidence actually supported denying even a restricted license after many years had passed. The judge ultimately finds the decision arbitrary and capricious, but there's still paperwork the defendant must complete. Court victories often come with one final lesson. Winning the ruling is one thing, getting every required document filed correctly is another.
Or reinstatement. I understand what they're looking for. Anyways, the court will defendant's request for, I'll start off with a restricted license for work appointments. That work would include not only work for which you're paid, but also work for which you're appointed or elected.
I get paid for that.
Well, I could, all right, I didn't know, but anyways, yeah, it includes your elected position as well. All right, and that will be for a year. Right. Therefore, I'm sorry, the court finds the decision to be arbitrary and capricious for the factors that Mr. Carnes noted, and the fact that you can't request statements or say somebody has to provide statements that say, yes, I know him really well and he doesn't use alcohol, and then say, well, I need a better letter. That's the definition of arbitrary and capricious, in my opinion. Now, also because there are prescription medications. Now, at the same time, I do respect and appreciate the opinion of the Driver's License Restoration and Appeal Division, and that is their goal is to help protect people riding on the roads, and of course, even the driver. And of course, if you're using any kind of controlled substance, then it can say you need to make sure you understand that you can't drive with any amount of that opiate or opiate in your system. So,
Hopefully I never have to take this stuff again.
I understand. All right.
It wasn't fun.
Madam Clerk, do you prepare that order?
Not today.
No, I know. All right.
I felt your staff here is awesome. Can I please say that?
You can, but don't say it out loud because they get really.
These people could barely fit their head through the door. No one here has found out.
Well,
It's been disrespectful. They're all great.
Hold on.
I'm from Grand Traverse, though.
All right.
Nice.
Well, what we need though from you, sir, is you need to prepare an order and bring it to my office. The court doesn't prepare those orders. The defendant normally brings them. I'm going to tell you in this, Madam Clerk, are you writing down the page?
I don't have it.
No, okay.
I don't. I'm sorry.
All right. What you can do, sir, is you can find the order the same place where you found the appellate form. Right, and so if you go on to michigan.gov.
No, is that where this one is? Because this form wasn't on. We actually had
It should be on the michigan.gov webpage. Am I right?
It should be on it will
On
probably be
scale.
on the legal help website as well.
Oh, so did you go to legal help?
For the paperwork to appeal this,
Yeah.
it was quite the challenge. Your staff helped me get
All right, well, you can try, if they're nice today, it is Monday, you can ask them for, and they'll give you the card for legal help. There's also michigan.gov, or if actually you type in SCAO forms,
And
write it down. It's okay.
I should just write it.
I'd throw it at you, but my luck, it hit you in the face.
And at least I'd have it. What is that form again?
Scale, SCAO forms. SCAO stands for State Court Administrator's Office,
Oh,
and they print, or they have forms on there for the most common standard forms, and they'll have one in there for you, okay?
thank
They should have one in there for you, and they're probably not in the office now since it's lunchtime, but anyways. All right, you submit that, all you gotta do is bring it to my window,
All right.
and you can leave it there. If I'm not there, then I'll sign it, all right?